21-160-918. This is William Buford versus Progressive Marathon Insurance Company. The matter is before the court for review on today's your appearance for the plaintiff, please.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff, P number 84581.
All right, thank you. Good morning, counsel for defendant in this matter, please.
Good morning, Your Honor. Rena Erba on behalf of defendant Allstate.
All right, your P number if you will.
P83692.
All right, thank you. Good morning to you as well. Somebody update me on the review regarding this matter. Go ahead, Madam Counsel.
Your Honor, we should also have a motion to refer this case to probate court. We're trying to determine if Buford is competent to testify in his deposition.
Okay, I didn't get that, counsel. You said you should have a motion. Go ahead, tell me again.
Yeah, there should be a motion hearing as well today. A motion to refer this case to probate court.
All right, see if I have that. I'm seeing a motion to compel discovery. That's the only thing that I'm saying. You filed something else, counsel?
Yes, Your Honor. I was told it was scheduled for today, but if not, then I'm not sure.
All right, we'll figure it out. That's for sure. Okay, so you are alleging by the filing of your motion that there is a person under disability. Is that what you're saying, sir?
Yes, Your Honor. We've been trying to depose the plaintiff in this matter, but he has some kind of mental disability that's preventing him from testifying. And we've been working with sister counsel, and she's been keeping us in the loop, and she's been doing everything she could to help us out. But at the end of the day, I don't know if he's gonna be able to testify, and we can't settle without some kind of statement from him. So we would like to refer this case to probate court. They can determine if he's competent, and we can go from there.
Madam Counsel, what are your thoughts in that regard?
Your Honor, the plaintiff is incompetent to testify. It will be really difficult for him to testify. So I was given information that he is assigned to a caregiver assigned by the state. However, we have been trying to get in reach with the caregiver, and we have not received any response back. The defendant motion was filed last week. However, plaintiff did not have an opportunity to respond to it. However, I'll keep it to the court's discretion as far as sending it to the probate court to determine whether plaintiff is incompetent or not.
Right. It doesn't. Well, let me start out. You were saying that there is a caregiver involved already. To the best of your knowledge, Madam Counsel, does that caregiver have letters of authority or anything along those lines?
Your Honor, I have nothing in writing to show that she is legally the caregiver for Mr. Buford. All I have is just, information directly coming from him that says that he has one. I have not spoken with her, and I have no documentation to prove that she is assigned by the state.
To the best of your knowledge, does there appear that there might be some competency problem with respect to Mr. Buford?
Absolutely, Your Honor, yes.
Counsel, what kind of order are you asking for? It does appear to be one of those situations where should issue for determination as to competency in this matter. What are you asking for, sir?
Yes, Your Honor. So I'd ask if the probate court does determine that he's incompetent, then we would request this court assigns him a legal guardian, and we can depose the legal guardian.
All right. I will sign an order for competency evaluation. Obviously, that is something that requires a determination by the probate court as to its competency. So I'll sign an order consistent with that. And I'm looking for issues of practicality in terms of how you get all that done. It doesn't even sound like there's anything filed in probate court at this time. And obviously, you could you know, hire outside doctor to make some kind of determination, but I think the probate court is the right way to do it. I'll sign an order granting the motion for a competency determination with respect to Mr. Buford. Are there any other issues that the court could be of aid in giving any direction on at this time? Or are we, is everything frozen in time with respect to this case, given the competency issues with regard to Mr. Buford?
Yeah, I'll just ask, would this case be stayed until those proceedings? Should I put that in the order as well, or just gonna give us another date and we can come back?
Yeah, that's why I was asking the question as to whether or not there are other things that we can make progress on while that process is ongoing, or is this issue with Mr. Buford, is that in fact the issue of the case?
Yeah, yes, Your Honor, that is the issue of the case, and we can't do anything else until that's taken care of.
All right, thank you, Counsel. Madam Counsel, anything at this point?
No, Your Honor.
All right, the court will issue an order for competency, and I'll calendar the file for the next 60 days. I'll bring it back after that time for review with regard to competency in relationship to Mr. Buford's matter. So
Thank you, Your Honor.
the day 60 days since approximately that date is
31st, May.
May 31st, 2022, and that's going to be at 9:45 a.m. All right, somebody's going to submit an order. You need me to generate one. What are you going to do?
Yeah, I'll submit the order, Your Honor. Should I put that new date in the order as well?
Exactly right, sir. And let me give you, you can email that order, get it to me more quickly. And why don't you take down this email address? That's Latifah, Latifah, dot, last name is Hunter, at 36districtcourt.org, 36th.org, 36districtcourt.org. So
I got it.
Latifah at 36districtcourt.org. I'll get that order signed up and out, and I'll see the two of you on the 31st of May, 9:45 a.m.
Thank you, Your Honor. I'll send that order out to you today. Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right, the court, I'll call case number 21-165-707. This is Jacqueline Spearman versus Across the Park. The matter is before the court, set on for a pretrial conference on today's date. The court did grant a period of discovery. Also, I believe I referred this matter for mediation. Oh, that's good. Anyway, let me get your appearance on the record at this time, please.
Good morning, Your Honor. Brian Blue, 66250. I'm here on behalf of the defendant.
All right, thank you, Mr. Butcher.
Good morning, Your
Mr. Butcher, did you put your P number on, sir?
I'm sorry, Judge, P66250.
All right, thank you. Do I have Jacqueline Spearman or someone for Ms. Spearman on this Zoom? Say something at this time.
Good morning, Your Honor. Yes, I am here, Jacqueline Spearman, on behalf of myself, the plaintiff.
All right, thank you, Ms. Spearman, and good morning to you. Mr. Butcher, to update me on this, I thought I might have sent it to some type of mediation. Maybe I did. What's going on, sir?
Yes, Judge, that is correct. Your memory is correct. We did, you did refer it to mediation. The parties, in fact, did participate in mediation. Unfortunately, mediation was not fruitful in terms of giving us any kind of resolution to the case. Last time we were before you, you did open up discovery and set the matter for review for today. On February 7th, I did send some discovery requests to Ms. Spearman. Following that written request up with an email to her, I think that was on February the 16th, to make things a little bit easier on her in terms of responding. And as of today, I don't believe I've received a response back.
All right. So the time period under the court rules has expired since the time that you sent the discovery request, sir?
That's correct, Judge.
All right, Ms. Spearman, so what's going on your end? It appears that counsel sent some items to you for a discovery that you're required to respond to by law, and that you have not responded to. Talk to me now.
Yes, Your Honor, that is correct. I did receive that email from the counselor. Unfortunately, I've been ill. My mom, my daughter, and my cousin has died from COVID. So that is what prevented me to submitting that documentation and my evidence to the court. I'm just asking if the court could have some leniency and give me a little more time to present my case to the court and get that discovery taken care of.
All right. Thank you, ma'am. Thank you for the update. I'm sorry to hear of the various items. These have been very, very difficult times. Sure. Mr. Butchard, anything at this time, sir?
Nothing further, Your Honor. I'll leave it to the court's discretion.
Thank you. Ma'am, if I extended the time for discovery or the time to respond, and give you an additional 30 days, could you get those answers and responses in that time, ma'am?
I'm sorry, I didn't hear you, Your Honor.
Yeah, Ms. Buren, I was saying if I gave you an additional 30 days to get answers to the items that were sent to you, would you be able to get those answers done in the next 30 days, ma'am?
I would not, Your Honor. If the court would please allow me a little more time.
All right. So, you know, it's been a significant period. Are you caring for other people? Or are you sick yourself? Or what's going on with you? You don't have to get go ahead.
I'm sick. I'm sick myself, and I've also been caring for my 86-year-old mother.
All right, ma'am. Well, under the extraordinary circumstances, I'll go ahead and extend the time to respond. I'll give you a period of 45 days, and I'm going to set a new court date just beyond that period. So you got to get that done within that period of time. The court rules allow 28 days, and we're way past that time. But given the sickness and illness issues, I'm going to grant you the additional time. The date that you'll be returning to me is going to be May 26, 2022. And I will see where this case is at that time. All right. So make sure you get those answers in before that date. They have to be prepared and served on the other side prior to the expiration of 45 days. The new hearing date is May 26, 2022. We will get an order out to you with the new court date on it as well.
Thank you, Your Honor. Does the court have a time available now, or will that just be on the notice?
I'm sorry, sir. Thank you. Thank you, sir. We're setting that for 9:30 a.m. and that will be on the notice.
Perfect. Thank you very much, Your Honor.
Thank you. Good day to you.
You as well.
Thank you, Your Honor. Thank you, Counselor.
Thank you.
Take care, Ms. Berman.
All right, this is case number 21-163-521. This is Community Financial Credit Union versus Megan Wigley. The matter is before the court, set on for a pretrial conference on today's date. The court did open discovery and extended discovery through today's date. It looks like there has been the filing of a motion for summary disposition. Your appearance for the Plaintiff Community Financial, please.
Good morning, Your Honor. John Mueller appearing on behalf of the plaintiff. Key number is 35413.
Thank you, Mr. Mueller. Good morning to you, sir. I'm looking now for Megan Wigley. If you're on the Zoom, Ms. Wigley, please say something at this time, ma'am.
Good morning, Your Honor. I am here.
All right, thank you, Ms. Wigley. I see that that there was a motion filed for summary disposition. It looked like the matter was timestamped on the 17th March. I'm looking. Did you file any written response? Did you file any written response to that, ma'am?
Yes, Your Honor. I replied with a response to Mr. Mueller, sent him an email, PDF of my responses, as well as overnighted the hard copy.
All right, thank you. Let's see. And Mr. Mueller, did you in fact receive the response to your motion, sir?
I don't see that I did, either hard copy or email. I mean, I can look for the email if I know when it was sent, but I did not receive a hard copy.
Yep, there was 2 forms of submission, hard copy overnight via FedEx, and then the PDF. And I have documentation for both.
All right. So he hasn't received a hard copy. When did you send the hard copy now?
I can tell you that in a few. Let me get these discovery responses.
Approximately how long ago?
It was actually March 9th that
Okay,
those were sent.
all right.
Well, maybe she's referring to the discovery responses, Judge.
Yeah, that's, I'm asking you, because the motion for summary disposition, man, that motion was filed, looks like with the court on the 17th of March. So you're indicating that you responded to some discovery items like request to admit and so on and so forth. Is that correct, ma'am?
Right. So those discovery responses. Now, anything after the 17th, I have not. Anything after the 9th, I have not received.
Okay, all right. So I have in front of me a motion for summary disposition that was filed with the court on the 17th of March. And you're saying it says that was served on you. In fact, it says it was served on the 14th. So you have not received the motion?
I have not. Now, what is this in addition to the discovery? This wasn't brought to my attention.
Yes, it's in addition to discovery. It's a motion for summary disposition and for judgment against the defendant. And just one moment, ma'am. One moment.
Okay.
And the nature of this motion is saying that after reviewing the responses to the discovery items, that there's not a genuine issue of material fact. The claim that the plaintiff is making is that this is in fact an indebtedness, and that nothing about the discovery responses in any way addresses that issue of whether or not this is an indebtedness that's owed. So they're saying that even with the responses to discovery, that does not in any way rebut the claim that has been brought before the court. And that claim is, of course, that there is an indebtedness owed as a result of a loan from Community Financial Credit Union. Looks like a loan that was related to, trying to see if this was a loan related to an automobile. But in any event, I see the loan document with one moment, I'm looking at dates here, dating back to 2015. So what the plaintiff appears to be saying is that there's a track record of there being a loan or some type of indebtedness, and that there were payments on this debt and obligation, but that the balance was not totally paid. All right, ma'am.
Understood, Your Honor. My response was to let Mr. Mueller know that I am not in the financial position to pay the total balance of the original loan of $12,646. I have repeatedly reached out to Mr. Mueller to try to negotiate and lay this debt to rest. I've offered 50% of that, which was $7,000. I believe that he came back and said that all bets were off, that he was not interested in any negotiating with the loan. I've repeatedly gave him my financial stresses in terms of paying back. I think he mentioned that if I could pay back $9,000 in 10 days, that he would negotiate that. I said that I could pay a huge, large sum of $7,000, and if I could be on a payment plan for the rest, I will pay that back. But he mentioned that all bets were off. So I'm just trying to put this to best, the best to rest, Your Honor.
All right, I got it. All right, gotcha. Now, I don't want to get into the negotiations as such, but you said that you are in a position to pay a substantial portion. You just want, you'd like to engage in a compromise to see if we can get this number down, because what they're alleging is that the total amount should be in the nature of $17,000. And I know that a lot of that has to do with interest that is accrued over that last 5 to 7 years. But it's basically your position that you can negotiate the top number in some kind of way that might help you get this resolved, correct?
Correct.
All right, Mr. Mueller, there's a lot of interest packed into this, sir. And if somebody's got about $7 grand or so that they're willing to come up with to try to pluck away at this, it does seem to be the kind of situations that there's typically some ability to negotiate. I know this has been going on for looks like 7 years or so. And of course, I know that you are experienced in these matters of many years. We have P numbers, shall I say, in the same ballpark. Although 9 is 39, yours is all the way back here to 35. We're not in those 19s that they used to be. But it seems to me that given the bandwidth of this case, economically, financially, that maybe there should be some room to try and find a way to some reasonable conclusion in this regard. And I'd like to take a moment. I know you guys have talked about it, but let's take another moment to talk about it a bit to see what you can do on this. The challenge here, Ms. Wigley, is of course, the longer these things go on, they get to be a different type of problem, a different type of challenge. I'm taking into consideration, of course, that COVID's been around for a couple of years or so, and that has had a significant impact on people in a number of different ways. So some of that should be considered in this regard. But you've indicated the willingness to set forth a substantial amount of money as a way to try to get this resolved. And I think that that's worth some consideration. So I'm going to see if you and Mr. Mueller can talk once again, if we get some of that interest out of there and put a lock date on when this can be taken care of. If you can kind of, $7,000 brings it to a certain place, and then you've got X amount of time that the parties agree on to finish it out. Maybe what you do is you enter an agreement at a higher amount, but if it's paid off by a certain target, then the balance of that higher amount is waived. But I can't make that happen. I'm suggesting that there may be a way to do it. Both of you, of course, are extremely articulate, so I'm gonna take my chances and put you in a breakout room in light of the things that I've talked about, and see if you can find some room in this regard. And Mr. Mueller, I appreciate you taking the time to go to breakout room number 1. And ma'am, I'm sending you a notice for that breakout room as well. And again, if the court can be other assistance in terms of trying to get this resolved, I will be happy to do so. It just seems to me that there should be room to do this. And I'm looking for you, ma'am. Are you still there?
Yes.
Okay, I got you. All right. And there is your notification, ma'am. All right, I'll speak to you, be sure.
Thank you.
Into the breakout room. All right, this is case number 21-145-709. This is neurospine coverage versus City of Detroit. The matter is before the court set on for a review on today's date. For the plaintiff in this matter, your appearance, please.
Your Honor, this is Joel Ashton, appearing for the defendant, City of Detroit, P number 47039. I did speak with plaintiff counsel this morning. She has a conflict, but I wanted to advise the court that we have reached the final settlement in this matter and are planning on submitting an order for dismissal this morning.
All right. Thank you, sir. Thank you for the update. And I will anticipate the dismissal with regard to this matter. Glad that the parties were able to reach a resolution in this matter. Thank you, Mr. Ashton. Good day to you, sir.
Thank you. Your Honor, can we email that to Ms. Hunter?
Yes, that would be perfect.
Very good. Thank you very much.
Got the email address correct.
Thank you.
All right. Thank you, sir. All right, the court is calling at this time case number 21-240874. This is Alexandra Nichols versus Paul Hughes. The matter is before the court regarding a review. Your appearance for well, let me see. Do I have Alexandra Nichols? Are you present? Say something if you're here, or your attorney. Please speak.
I'm here, Margaret Tracy, on behalf of Ms. Nichols, who's also present.
All right, who's counsel for Ms. Nichols? Please enter your appearance.
I'm Margaret Tracy.
Your P number, if you will, Madam Counsel.
63840.
All right, thank you, Counsel. Good morning to you, ma'am. Good morning to you as well, Ms. Nichols. For the defendant in this matter, your appearance at this time, please.
Good morning, Your Honor. Paul Hughes, P36421. However, I am representing myself in pro per at this moment.
All right, thank you, Mr. Hughes, and good morning to you, sir. When this was last before me, I think it was brought to my attention that there is a counterclaim that has been filed in this matter, and there was a request for a default on the counterclaim. I set the matter over that I would review it on today's date. Mr. Rassi, anything you wish to chime in on this matter at this time?
No, Your Honor, I had actually motion to set aside the default ready because I thought that was going to be defaulted. So it asked just like 7 days for us to be able to respond. And then I think we are going to need a mediator or something to resolve the matter.
All right, have you and Mr. Hughes talked at all about this or no?
Just simply that he would like to proceed with a default, that's all.
Mr. Hughes?
Your Honor, excuse me, this matter, as you noted, was set for review off our last court date 2 weeks ago. At that point, I proposed that pending a landlord-tenant hearing that we had on the 18th, which was 3 or 4 days later after our last status conference, that depending on the result of that landlord-tenant matter, I would be open to dismissing all claims, mutual dismissal of all claims at that time. Fortunately or unfortunately, on the landlord-tenant matter, which occurred 3/18, Judge Alicia Jones Coleman was not available, and the matter was set over to May 19th, or I believe May 9th. However, Ms. Teresa and I we have talked the day before the hearing. We discussed a statement be provided by Ms. Nichols that she would return all keys to me from the premises. She has moved from the premises as of 3/18, 2021. I still stand by that. However, the defendant or the plaintiff and counter defendant still has not returned the keys to my premises. She is 6 days overdue. She can walk into my house at any time. And I am strongly urging the court to enter a default, a formal default against a counter defendant counter defendant, yes. This matter, the court, I'm sure, recognizes from the Register of Actions.
Let me stop you for one moment, Mr. Hughes, and I'll come back to you. You said that, she left the premises in March of 2021. Did you mean this year, 22?
Yes,
Oh, okay. Okay, I got you now. I thought there was something.
I moves fast.
Yeah, for sure. Go ahead, sir.
Judge, I'm still willing to abide by a mutual dismissal of all claims. In this matter, we can file the dismissal of the landlord-tenant matter before Judge Alicia Jones Coleman, provided Ms. Nichols, through the statement that her attorney has provided, that she would return all keys to my premises. As the Register of Action shows, Judge, Miss Nichols was at least 60 days overdue before any action was taken regarding the matter, the fact that she was in default. The court was patient enough to put this matter over for review for her, and also to determine what would happen in the landlord-tenant case. There is absolutely no reason for a delay to allow her counsel to file a formal motion to set aside default judgment. Miss Nichols is a highly intelligent. She has no problem reading pleadings. She, in fact, is an employee with the Detroit Public Schools as a reading coach. She also, so there's no deficit there. Furthermore, she certainly cannot plead indigency, as she holds 2 jobs. So there's just no valid reason not to enter it today.
You stop for a moment. It seems like a promotion with a demotion at the end. Obviously, Ms. Nichols displays a significant amount of intelligence. She's aware of the proceedings that are here, and was informed the last time about how she had not responded to the counterclaim in this matter. That is a critical issue because she's in default on that. This has nothing to do with relative intelligence. It has to do with the application of court rules. Madam Counsel, Mr. Rassi, it does seem to me, given that there is this default that is pending here and the challenges that would be associated with that, I mean, that's what the case is now. Counsel has offered that perhaps the best thing to do with regard to this matter is for the parties to go their separate ways. Ms. Nichols has in fact moved from the property. He says he wants his keys back. He'll dismiss his claims in exchange for the dismissal of her claims and a stipulation to dismiss the case that's in front of Judge Alicia Coleman, no relationship as well. That seems to be the proper way forward in this case. Otherwise, where the one matter is now, the counterclaim, I'd have to enter the default. It's already in default. I have to enter the judgment on counsel's application, and then I expect that I would then receive some type of motion to set that aside, and I'll review it and see why it wasn't answered for a couple of months or whatever period it's expired. But again, I don't know that I don't know that benefits either side here, when the reality of this is that it probably is the kind of case where both sides need to walk in their own separate directions and go on with their lives at this point. I don't expect you to respond or directly answer on that, but I kind of want your thoughts if you will, at this point now, Counsel.
I can certainly talk to her about just dismissing the claim and moving forward. That's fine. I believe that she had turned over the keys, and I thought this was kind of like a separate issue because the landlord tenant has been resolved, but this is a different issue. So, but I can certainly speak with her about that.
Yeah, well, okay, John, I'll send the two of you to a breakout room to kind of discuss, because quite frankly, it's kind of a little bit in the air for the court because of the court rules on that counterclaim. That's the.
I understand.
That's the gum in this, it's got stuff kind of stuck up a little bit. So,
right.
Ms. Nichols, I'm going to send send you to breakout room number 2 to give you a chance to talk privately with your counsel. And then you guys come back into the Zoom, and then I'll come back to this case and address whatever
Okay,
issues.
thank you.
So there's your notification.
Thank you.
There's your notification. All right, I'll come back to this matter, Mr. Hughes, in just a moment. And welcome back, Mr. Mueller, and thank you for taking the time you have. Welcome back. So Ms. Wigley, you here with me, ma'am?
I'm here.
All right. Mr. Mueller, any updates that you can give me regarding this matter?
Yes, Your Honor. Thank you for giving us the time. This time we were able to reach an agreement we'd like to place on the record. It's a brief agreement, if we could do that.
Mueller, go right ahead with the agreement. Ms. Wigley is listening, and I will make sure that we have a understanding regarding what that agreement is. Go right ahead, sir.
So Ms. Wigley has agreed to pay $9,500 in full settlement and to pay that to my office. It'll be made out to Community Financial, but to pay it to my office no later than April 11th. So the due date will be close of business Monday, April 11th, for her to deliver $9,500 to my office. She can mail it, overnight it, drop it off, whatever, as long as it's there. I close the business on April 11th. If she does not do that, she has agreed that I can enter a default judgment against her for the full amount paid for in my motion of $17,767.18. And I'll submit paperwork to her via email, hopefully today, no later than tomorrow. And then assuming she signs, we'll submit that to the court. If she pays the $9,500 on or before the close of business April 11th, as the agreement will state, then I'll send her a stipulated order of dismissal with prejudice. If she, once the check clears, assuming she writes a regular check, I'll have to wait for it to clear. Once it does, I'll send her that stipulated order of dismissal with prejudice. If she does not, then of course I'll submit the default judgment to the court.
Ms. Wigley, were you able to hear Mr. Miller discussing the terms of the agreement, ma'am?
So the connections was going in and out, but just to be on record, I've promised to pay Mr. Mueller $9,500 no later than April 11th, given the exchange of the case being dismissed. Also, with Community Financial, I am looking for the credit report to reflect settled pay as full, zero balance.
All right. So that sounds like the agreement that was reached, except for two things. One, the agreement is that if the amount, the $9,500 is not paid for some reason by the 11th of April, or the payment does not clear the financial institutions, then the plaintiff would have the right to have judgment entered by default on the full balance of $17,767. But that's if, for some reason, the $9,500 payment is not completed. If it is completed, then this case would in fact be dismissed, but not only dismissed, it would be dismissed with prejudice, meaning that that would be the complete and total end of this case, and it would not be the reflection of any judgment or anything on your record, and it would mean that that any financial obligation that you have in regard to this particular claim would be total and completely and finally settled and resolved. Is that the agreement that you understand, Ms. Wick?
Yeah.
And that's the agreement as you understand it as well?
Yes, Your Honor.
Mr. Mueller, that's how you articulated, that's how you understand the agreement as well, sir. Correct, sir?
It is. I just want to address the other condition that Ms. Wigley mentioned. I do not address these matters with credit bureaus, so I don't want there to be any misunderstanding. My client will, but after representing them for a number of years, I'm pretty certain that it will not be marked as paid in full. If it'll be shown as some sort of settlement and done, but it's not going to say paid in full. It probably says settlement in full, zero balance, something to that effect.
So it's fine. It can say settlement, zero balance, as long as there's no remaining balance reflecting on a credit bureau,
Yeah,
which Community Financial can do.
Okay, yes, she's right, Judge, and that's fine. I just want to make sure there was no misunderstanding.
Yeah, a lot of times.
Just being crystal clear.
Yeah, hold on one second. A lot of times we don't know really how things read out to the credit bureau, but one thing you have for sure under this agreement is that the claim has been totally settled and there's no more obligation related to this claim. That means that that's how it should be reported by the community credit union. But it also means that you'll have the settlement document that will give you the authority to go to the various credit bureaus and let them know exactly what happened in there, and that your credit reporting or the credit reporting should reflect this resolution that shows that you have no outstanding obligation. You understand, Ms. Witten?
Yes, sir.
All right, so Mr. Mueller, you can go ahead and direct that document to me. Ms. Megan, is it okay if we put your signature on that just by permission, by consent? What that simply says is that the court is going to review this document, make sure that it says what the parties agreed to. By that, you allowing your name to be put on there by consent. I won't sign it unless it has what you all have agreed to. And then if for some crazy reason you get a document that's different from what we agreed to here, then what you do is you come back on the Zoom any day, you have the number, and you say, Judge Coleman, I got this order, but it's not saying what we agreed to. And I will set up a hearing and make sure that that gets taken care of. You understand?
Yes, Your Honor.
That makes sense to you for us to do it?
Thank
that way
you.
now?
Yes, sir.
All right. He's gonna go ahead and send, that is Mr. Mueller's going to go ahead and send that document with your name on it by consent. I'm going to review it, and if it says what it's supposed to say, I'm going to sign it, get it right out to you and to Mr. Mueller, and then if there are no problems, that will be the end of this case.
Can I ask a question, Judge?
Yes, sir.
So you want me to submit the order signing both our names, and then you'll review it and enter it if you agree that it meets the terms that we talked
That's
about
correct.
today? Okay,
That's correct. You can do it by email, and Ms. Wigley's name will have by consent, and that is under the court's direction.
and I'll email her a copy. Do you want me to email it to the court or just mail it?
Yeah, you can email it to the court.
Can
You
you
have the
provide me
email
with an email?
I'm sorry, what did you say, sir?
Can you provide me with the email address to make sure I get it to the right place?
Yes, sir, to the court would be Latifah, LATIFAH dot, the last name is Hunter, at 36districtcourt.org.
Okay, I'll take care of that right away. Thank you.
All right, thank you. And Ms. Wigley, thank you, ma'am. Good day to you. We'll get that order out to you right away. And I know April the 11th, we're looking forward to having this done once and forever.
Thank you, Your Honor. Thank you. Have a good day.
Thank you.
Bye-bye.
Bye now.
Mr. Rassi, I see that you're back, ma'am. Welcome back. I see that Mr. Nichols is here as well. Mr. Hughes, I believe it's Mr. Hughes. Are you here, sir?
Thank you, Your Honor.
Yes, sir. Mr. Rassi, anything at this time now? Okay.
Ms. Nichols agrees to dismiss the case.
All right. So, Ms. Nichols, I know that you've talked with your attorney and you've heard some of the direction that the court kind of gives in regard to this case. I'm of the firm thought in reviewing even-handedly the interests of the parties on both sides of this. And I thought that it may be at this point the best thing to do is for the parties to go their separate ways and put this behind. I know you've had a chance to talk to a lawyer, and she says that you are in agreement with that. I honestly, I take a moment to kind of talk about it the way I'm talking about it, but I do honestly think that that's the best thing to do in this case. I can't tell anybody what to do. And the next step this would be for the court to enter a default judgment, and I don't think that that serves the interests of either side in this. This is a landlord-tenant dispute that went left and right again. I think it's time that the parties should simply be able to go on and move on with their lives and put this behind. You're in agreement with that at this point, Ms. Nichols as well?
I am Judge Coleman, and thank you for holding this matter over until the landlord-tenant matter was seen about, and for me to have an opportunity to get a lawyer. May I make one more statement?
Yeah, go ahead, ma'am.
Thank you. And I thank you for your previous statement. I just wanted to say that because I met Mr. Hughes through a friend, and I know that he's thinking to move in his home more into a rented room or rented house situation, that place needs inspection before anyone else goes in. And I don't know if Mr. Hughes has those permits or has that permissions from the city of Detroit, but his home is in no shape for any tenant. I scrubbed and cleaned with my boyfriend to make that upstairs flat livable. It's my understanding from my boyfriend, he has another tenant in there. I don't know how. I don't know how, but the keys that I had for the home, Mr. Hughes, I had to find the keys with my boyfriend on his dining room table, which hasn't been cleaned in maybe 10 years. And the keys that I did have, I left. He changed my bedroom door key, so he has that key. And the key that my boyfriend has been using to get in and out to get my mail, he gave a key to my boyfriend, so he'll have to ask Robert for that key. But I left my keys because I never went back in there after I filed a PPO against Mr. Hughes for his erratic behavior.
So, Mr. Hughes, when you have the information regarding the keys, did you give the keys to the boyfriend, Mr. Hughes, for some reason, sir? Or a key or something?
Your Honor, the boyfriend had the keys. Ms. Nichols has the keys. The lock was changed because there was a leak for 1 or 2 days, and I needed the repair person to come in. The key was handed to Miss Nichols within 5 minutes of me finding the new key and giving it to her. With regard to the relevancy of the condition of my home, it has none. Miss Nichols, as we often hear in landlord-tenant court, would be asked, if it was so bad, why did she live there for 3 months? She apparently found the premises completely compatible with her needs at that time. And as far as her call for an inspection, completely irrelevant and beyond the scope of this agreement. I take great exception to it. But I am happy that we've resolved our claims.
Yeah, I'm glad you resolved the claims. I think for sure that this is a way to do this. I've heard that question before. If it was so bad, why did you stay there? And I was a landlord tenant judge for a number of years. That's one of the dumbest questions on planet Earth, because people stay at places for a whole host of reasons. Sometimes because they don't have anywhere else to go, et cetera, et cetera, et cetera. But that question is not really a relevant question. And likewise, the question of what Mr. Hughes is going to do with the premises now that Ms. Nichols is gone, that's not a relevant question for her or for these proceedings. Certainly, where the law is in the city of Detroit now is that such properties are to be registered, they are to be inspected and certified. So that is what the state of the law is. But as it relates to this particular case, it has no relevance. And just like it has no relevance as to why a person stayed at a property if it wasn't up to the condition that it should have been up to, unless you're having the landlord-tenant case. It could be that they didn't have anywhere else to go. They could not make that transition quickly. It also could be that they caused damage to the property and decided to stay because it was their damage. I don't know what it was all about, but ultimately, those two questions at this point, they don't really mean a whole lot here. The right thing, I'm even more convinced now that the right thing for these parties to do is to go on about their business and to mutually dismiss their claims and let this go in whatever direction it has to go, separate from each other. So I will enter an order based upon the stipulation dismissing this case. And I believe the parties have agreed and stipulated that the case before Judge Alicia Jones Coleman will be dismissed also. And I'll leave it to Mr. Hughes to submit an order consistent with the same hearing. Right? I wish all parties well.
Thank you.
Thank you.
Thank you.
Thank
Have a
you,
good day,
Your Honor.
Judge.
All right, this is case number 19-165-341. This is Flagstar Bank versus Sierra Burlich. The matter is before the court set for a motion to set aside a default judgment in this matter. For the plaintiff, your appearance at this time.
Good morning, Your Honor. James Zellin appearing on behalf of the plaintiff P69241.
All right, thank you, counsel, and good morning to you. Your name for the record, ma'am?
I'm Dana. Sorry, my name is Dana Hale.
All right, thank you, Ms. Hale. And Ms. Hale, why are you here, ma'am?
I'm the owner of Irving's Professional.
Okay, and so it looks like the defendant, sorry, it looks like the plaintiff filed something against Irving Professional because there was some indication that the defendant in this matter, Ms. Burlich, was working for that entity. Is that correct?
That's not correct. Well, they filed, yes, but she
Oh,
was
you
not
gotta listen
working.
to this. Stop. Yeah, you gotta listen to questions, man. Okay, if I ask you something, you know, you've been sitting there a while, you get to see how the people talk. Boy, one of the things I don't care for is if you don't listen to my question. Don't answer my question until you listen to my question, okay?
Okay.
You understand me? And when you have something to tell me, I'm gonna listen very carefully to make sure I understand what you're saying, okay? Because if I sit here and I ask you, did they serve some paperwork to your business or whatever, and you tell me no, then I'm sitting there like, well, why are we here? That's why you gotta listen to my question, okay?
Okay.
That's very important to me, okay? And I wanna hear what you have to say. I'm gonna hear from this side. I wanna hear what they have to say. That's the way I do it, okay? So, sir, I don't have the defendant here. I have Irving Professional. Oh, wait a minute. I do see Miss Burlich on the Zoom. Say good morning, Miss Burlich.
Good morning.
All right, thank you. So you have a judgment against you, ma'am, and that judgment was entered on the 31st of January, 2022 for $6,408.71. Subsequent to that time, it looks like the plaintiff filed something against your a place that they claim that you were working. And it looks like, well, let me make sure my notes are proper here. Hold on one second. So the judgment was entered against you in 2019, 7/11/2019 for $6,215.33. It looks like a garnishee default was entered on the 31st of January 2022 for $6,408.71. Right. So Ms. Burlich, tell me why you're here, first of all, ma'am, because it looks like this is a petition and affidavit to set aside the default that was filed by Ms. Hale on behalf of Irving's Professional. Ms. Burlich, please.
Well, I'm here firstly to get in contact with what's going on. How I got the check was because it came in the mail to me and I went to go cash the check. It went through, nothing happened until I got a letter. Well, I got served a big orange envelope. I didn't really get to read it too much. I had misplaced it or whatever. But I just got this new letter in the mail, a notice to appear.
Okay, all right. So you didn't file anything like a motion to set aside default. You didn't file anything like that with me. Is that correct, ma'am?
That's correct. But yeah.
All right, gotcha, Ms. Rhodes. Just stand by for a moment, ma'am. Counsel, go ahead, sir. I do have Miss Hale here on behalf of Irving's professional, sir. Go ahead, sir.
Your Honor, I did receive the court's notice to appear today. Ms. Hale never filed a copy of her motion with my office, so I don't have that, so I can't respond to her motion. Further, the Urban Professional Nursing Home is an LLC, and Ms. Hale would not be able to represent the LLC without being an attorney, and I don't believe she is so.
Yeah, what would she have to do with this?
That's really not your challenge at this point.
Okay.
What the document that's submitted by Ms. Hale indicates, well, one of the things counsel is saying is that corporation in Michigan has to be represented by an attorney. But one of the things that Ms. Hale is saying here is that this person never worked for her agency. She says that she owns a staffing company and people came in to apply. They must fill out form information and also direct deposit information. She says there are some 369 persons that work with the agency, and she's never been served with any papers or garnishments. So it appears that what Ms. Dana is bringing to the court's attention is that she do not have any employees under her control, and that therefore this should not be a garnishment against her agency, that the garnishment should remain as a relation to individuals. The challenge that's here is that when the plaintiff filed its garnishment, someone was supposed to respond to that within a certain number of days. Otherwise, it turns into a default and the judgment is entered on this matter. All right, so anything you want to say at this time, ma'am? Go ahead.
Yes, so.
Why don't you, since you're in the case, bring your mask down. So there you go, ma'am.
Okay, so when I received.
One second. Are you able to hear? Counsel?
Yes, I am.
Madam Reporter, are you able to hear?
Yeah, I can hear it.
All right, try and keep your voice up as much as you can, ma'am, because we're trying to make sure we get what you have to say. Go ahead, ma'am.
Okay, very good. So when I received the information about the young lady that filled her paperwork to work for our company, I received it at the post office. So our mail is held at the post office because during COVID, we was having a lot of issues with mail and not getting our checks and things like that. So we never received any information that we were even served until I went to the post office and got the information. Once I received it, I called the attorney and told the attorney that Tier never worked for the company and that there was no way for me to garnish someone that didn't work. And at that time, we filled out that paperwork. Had the HR rep send it back to the attorney, and that's when I came down and filled out the motion to set aside because we knew nothing about any of this at all.
All right. So Ms. Burlage, were you planning on taking some type of approach to begin trying to pay this judgment, or what are you planning on doing in this regard?
I'm trying to figure out how do I have to pay back something that was sent to me? Like, how did y'all let me cash a check that couldn't have been cashed? Like, what? I don't get it. I've been trying to get in contact with these people.
Okay, but you, I guess what you're saying to me is that you did cash it, you got some money, right?
Correct. Yeah.
I guess. Well,
But
where's the
it's
money?
with JJ Marshall and Association. So I've been trying to see how I could pay them back. I didn't know like it was still with Flagstar.
Okay, well, whoever it's with, you only have to pay one entity, you don't have to pay both folks. And since you got a judgment against you, the judgment is with Flagstar, so that's the agency that you would be sending in money to.
In your
Okay.
honor, I may be able to add to that. JJ Marshall is hired as a collection agency. They did not, Flagstar Bank has not transferred the debt to JJ Marshall. They're just a collection agency that's been hired to aid in the collection of the matter. So there will not be two entities that are claiming rights to this. It's only one.
Yep, I got it. So, Ms. Burlage, are you prepared now to enter into some type of payment agreement to start dealing with this?
I can set up a payment plan. I mean, I haven't been working, but I just took a drug test for crisis. So hopefully I'll be working soon.
All right, so maybe I'll let you talk with Mr. Zelen in just a few moments to see if something like that can be worked out. Counsel, you raised a couple of challenges here. And one of them that addresses the issue of the need for counsel, maybe one that we have to, that I have to drill down on that as required by some of the rules here. It seems to me, in trying to get at the core issue here, that Ms. Hale is the person who owns and operates this business in reality, and that she says that this person that she doesn't have an employee relationship whereby she would hold or has management of control over any funds, and that the failure to timely respond was secondary to postal issues, and that she would ask that this judgment be set aside against the agency.
Correct.
Your Honor, the party in this matter was properly served. It was served both via certified mail as well as personally served. It was personally served to a person in charge on November 1st, 2001. We did not receive a disclosure. We then sent out a 28-day letter demanding a disclosure. If Ms. Hale called my office, she would have spoken with me, and I would have indicated to her that we were looking for a disclosure and one would need to be filed. I don't believe there's one in the court file, and there's not one in my file. There was no disclosure ever filed. I can't just take people's word over the phone. That's not going to go well with my client. And if I just let them know somebody called me, they wanted a sworn to disclosure with a signature stating the fact that the person doesn't work there.
I don't work.
The defendant didn't file, the garnishee defendant did not file the proper paperwork. It is clear what their responsibilities are. They've had every opportunity to respond to it. I would ask that if the court is going to set aside the default as to the garnishee defendant today, that there be costs awarded for their wanton failure to respond, which incurred further expense to plaintiff to try and get them to do what they were supposed to do. And
can I say something?
No, not yet, Ms. Burlage.
Okay.
So there are two things. There are two things here and trying to work through this. One is that if I send it back, I think that at some point the default is likely to be set aside. Procedurally, I would delay execution and send the owner to get a lawyer and come back and so on and so forth. The other side of this is to go ahead and set it aside now with the assessment of cost. 6 in one hand, half a dozen in the other. That's probably the better thing to do, is to set aside her cost. By the time she goes and hire a lawyer, she's going to be out of much more than what the cost would be in this situation. So I'm going to err on the side of, because this is kind of unusual, I'm going to err on the side of granting you the right to have that judgment set aside against the agency. Because there was not a disclosure file that's required by law, then costs would be assessed associated with that. Counsel, what are you asking for by way of cost, sir?
I would ask for $300, Your Honor.
That's not unreasonable. I will assess cost at $300. I'll set the judgment aside on that basis. So the setting of the judgment aside is conditional on a payment of $300, and then this judgment is set aside. And so it's back to Ms. Burley. So, and Ms. Burley, I'll come to you in just a moment, ma'am. So,
Okay.
I don't know why every time I get ready to call your name, Dana stands out. I always get Hale. So Ms. Hale, you will need to pay. Your agency would need to pay to the plaintiff in this matter the total sum of $300 as cost, and then the judgment will be set aside. So you will direct that to Mr. Zellen's office, and that information should be on a copy of the documents that you have. So you want to do that right away, because as soon as you do that, I'll get an order that will dismiss that judgment.
Okay. Yeah.
All right, so you'll take care of that within the next 7 days, ma'am?
Yes, it can be done today.
All right, she says it'll be done today. I'm gonna give her within 7 days. That's just kind of the way we set those things up. As soon as you pay it, I should get a order dismissing this in my files. Right.
Can I say
Yes,
something?
ma'am.
I just want to kind of make it clear that if we didn't receive anything, I don't have a problem with paying $300. But if we never received anything, and he said 2001 on record, we wouldn't have anything from 2001. We have cameras in our building, and it's multiple employees that come in and out of the building. So if an employee signed for something while the receptionist was in the restroom or what have you, we shouldn't be responsible for anything, because I didn't get it. I never got it.
Let me correct you on that. If, as is indicated in 2021, I believe,
Okay.
that someone served a document, somebody signed for something. Once that's done, doesn't matter whether you get it. If somebody signed for it, they send it off in the corner somewhere. Then the period begin to start running as to when you have to do the disclosure.
Yes.
And then the second part of this is that, and you didn't know this because typically, companies have a lawyer involved, but there are other things associated with that. The first thing that you do when you get any notice that anything's going on is file a disclosure. That disclosure is everything. And oftentimes, as might have been the case here, that disclosure would simply say, not employee, not holding any money, 0000, and you send the form back. That's the end of it for you. When there is an agency, oftentimes it's easier to get money from an agency than it is from an individual. So if that agency doesn't respond, then the next step is to go with the 28-day letter and then get a judgment against the agency. Now they got to pay the money.
Yes, I understand wholeheartedly. I'm just saying that I never received that to even fill out a form. We have a payroll company, and we also have Sharon Clark, which is our attorney at the business.
Yeah.
We have not received anything besides the letter that we got from the post office that was certified.
Right.
So I would have took care of it, because we have a payroll company.
Yeah.
That's all I'm saying.
And I think just to kind of respond to that, because I don't know anything you're saying. One of the things that I think you want to do is make sure that whoever is anywhere within the agency that might receive documents or anything that they immediately inform somebody, so that nothing gets set aside. Because if it's something like this, it becomes a kind of problem. I'm sure you got a process involved because, you know, you're here now. But,
Yes, most definitely, but within COVID,
Yeah.
we went through so many employees, so I don't know who signed anything, if they did sign anything, that's why I'm here.
There you go. All right. Well, I'm glad you got it worked out. I think it's a reasonable way. The other way was to adjourn it and then have to bring a lawyer, and that's usually $1,000, $1,500 and so on. So
Absolutely, I understand, thank you so much.
all right, so I wish you well, and that judgment will be set aside. Okay, Ms. Burlage, I'm thinking that you probably want to take a moment at least to talk to Mr. Zeller and see if you can come up with some type of agreement to make monthly payments to see if you can try to get this resolved. Would you like to do that, ma'am?
Yes.
I'm gonna send you to breakout room 1, and I'm sending counsel there and see if you can make some progress on this. All right. There you go.
Okay, thank you.
All right,
So much, I appreciate
Thank you.
it.
Good day to you.
Okay, have a good one.
I'm seeing de Blasio on the Zoom.
Yes, Your Honor, I'm here.
What case are you here on?
Case number is 21-151911. I believe it was set for a status conference.
Buford versus Progressive.
No, it is ASP Cares. The patient is Andre Sewell versus auto owners.
Yeah, that's the thing. Yep, you stuck it in that. You stuck it in that wrong one.
All right, this is case number 21-151-911. This is ASP Care or ASP Care's pharmacy versus homeowners insurance company. Your appearance, counsel.
Good morning, Your Honor. Jalise DiBiase, P79916 on behalf of defendant auto owners. And so the court is aware, I spoke with plaintiff's counsel not too long ago. She had to leave for a doctor's appointment, but she is aware of the status conference and what we have to update the court with, which is not too much information.
So what's going on?
If you recall, Your Honor, we had an order to stay proceedings. It was entered January 11th of this year pending our appeal. And then in that order, the court had us come back on today's date just for a status conference to check in. Since that date, our appeal application was filed December 7th of 2021. It has been assigned to Judge Sullivan, and we are anticipating a briefing schedule to come through soon, but we don't really have any more updates at this time. We've been told Wayne County is pretty backlogged, so we expect it will take some more time.
Got it. All right. So I'm going to go ahead and calendar it for 60 days just for review, and so I'll have it come back for review on.
You want to go into end of, or you want to end of
First week of June.
June, yes, June June 2nd. I mean June 1st.
June 1, 2022, June 1st, 2022. And I'm setting that off at 10 o'clock a.m.
Okay, June 1st, 2022 at 10.
That's correct.
Awesome. Okay.
All right, thank you, counsel.
Thank you, Judge. Take care.
And Mr. Zellin, welcome back, sir, and welcome back also, Ms. Burlage. Thank you for a moment of courtesy just to try and talk about partial payment or some type of plan to start maybe tackling this. Sir, you'll update me on what the status is.
Your Honor, Miss Burley's not working currently. She did indicate she's hopeful to be receiving employment through Chrysler recently or soon in the near future. At this point, with her unable to work, I'm not going to be able to get my client to agree to a payment with what she can afford. But when she is gainfully employed, hopefully with Chrysler, I told her that she could contact my office and I'd be happy to set up payment arrangements at that time when she knows what she will have coming in and what she could pay and when she'll get paid.
Thank you. Ms. Burrow, does that make sense to you, ma'am?
Yes, it does.
All right. And you also always have the right to file a motion for partial payments with the court. It's good when you can talk to the other side and try to work out. If for some reason you're unable to do that, you could then file a motion with the court and ask the court to come up with a payment amount as well. Understand?
Yes, sir.
All right, so I wish you well, ma'am, and hopefully you'll be able to get something worked out in the future to try and start tackling this issue.
All right. Thank you so much.
And Your Honor, for quick point of clarification with regards to the garnishee defendant, am I to submit an order once she makes payment?
Yes, sir.
Okay.
I was going to simply enter some dismissal, but I want to make sure that the payment is cleared and then so that will put it kind of on you.
Okay.
Thank you, sir.
Sounds good. Thank you, Your Honor.
Hey, so what was that lady's name in the courtroom? Hale with the H?
Yeah, H-A-L-E. Dana, D-A-N-A. Last name Hale, H-A-L-E.
Okay, thanks.
Going down to Memorial. It's at 12:30. They got me in now.
That's a lower level fight.
Yeah, today at 12:30. Yeah, we're about to go through our rehearsals right now. See you in a minute. We gotta get off that out your thing.